19 state capitals, 19 attorneys general, 19 governors, and every single one of them woke up on June 22nd, 2026, to find that the regulatory strategy they had spent weeks building, the strategy designed to survive every Supreme Court gun rights decision, the strategy that their legal teams had labored over, their lobbyists had funded, and their legislators had fast-tracked, was declared unconstitutional by all 9 justices of the Supreme Court simultaneously in a single opinion with 0 dissents. Torres v. Illinois, decided June 22, 2026, is the case that gun rights advocates had been predicting since Bruin in 2022 and that 19 states built entire post-Carson legal architectures to prevent. But it came anyway. 9-0. All 9 justices agreed that what 19 states had done in the weeks following Carson, Coleman, Morrison, and the other 2026 gun rights decisions constituted a pattern of constitutional evasion so systematic, so calculated, and so transparent that it could not survive judicial scrutiny under any constitutional standard. Torres v. Illinois eliminates mandatory training requirements beyond a minimal threshold, strikes down application fees beyond a minimal cap, ends processing delays beyond a defined maximum, invalidates sensitive place designations covering more than a specified percentage of publicly accessible space, and creates the procedural suffocation test, a constitutional standard that applies to any combination of regulatory requirements and asks not whether each requirement individually violates the Second Amendment, but whether the combination functions as a practical prohibition on the exercise of the right. Subscribe now because Torres v. Illinois affects every gun owner in America and every politician who thought they had found the constitutionally durable workaround that would survive the gun rights revolution of 2026. And the answer from 9 justices is that there is no such workaround. There never was. And every person in every one of the 19 states who was denied or delayed in exercising their Second Amendment rights under these systems is entitled to immediate relief and civil rights damages starting today. Gabriel Torres was a Virginia resident who attempted to purchase a firearm and carry it for self-defense following Carson's elimination of Virginia's permit requirement. Virginia's response to Carson was to enact emergency legislation creating the Virginia Responsible Firearms Training and Safety Program, requiring 16 hours of state-approved training, $450 to $600 in course fees, a psychological wellness attestation signed by a licensed mental health professional, $200 to $350, a $175 processing fee payable to the Virginia State Police, a 45-day processing period, and carry restrictions in locations designated as sensitive under newly enacted Community Safety Zone ordinances covering all public transit, all parks, all shopping centers, all entertainment venues, and all private businesses without specific firearms welcome signage, approximately 78% of publicly accessible spaces. Torres calculated the total, $825 to $1,125 in fees and evaluations, 16 hours of mandatory training, a 45-day delay, and effective prohibition on carry in 78% of public space. He challenged the entire framework as a functional prohibition, even though no single component was a categorical ban. The Western District of Virginia denied relief. The Fourth Circuit affirmed. The Supreme Court reversed 9-0, creating the procedural suffocation test and applying it to 19 states simultaneously. Number 1. What Torres v. Illinois held. The procedural suffocation test. The core holding. When a combination of regulatory requirements, individually non-prohibitory, functions in combination to make the practical exercise of Second Amendment rights inaccessible, expensive, or time-delayed beyond a constitutionally tolerable threshold, the combination constitutes a procedural suffocation of the right that violates the Second Amendment, regardless of whether any single component would, in isolation, survive scrutiny. The test asks not, is this requirement constitutional? But, does this combination function as a practical prohibition on constitutional rights exercise? Component 1. The training requirement limit. Training requirements exceeding 2 hours in total duration are presumptively unconstitutional as applied to Second Amendment carry rights. Training requirements imposing costs exceeding $75 total are presumptively unconstitutional. Training content beyond basic firearm safety, handling, storage, loading/unloading, is presumptively unconstitutional. Virginia's 16-hour, $450 to $600 training requirement, void. Component 2. The fee cap, Application fees for any process related to exercising Second Amendment rights cannot exceed $50 total, including all processing fees, fingerprinting fees, background check fees beyond federal NICS, and administrative fees. Torres holds that fees beyond $50 function as wealth-based barriers to constitutional rights exercise, applying the same logic as Harper v. Virginia Board of Elections, which found conditioning the right to vote on a tax unconstitutional. Virginia's $175 processing fee, void. Component 3. The processing delay. Maximum. Processing delays for any background check or application related to Second Amendment rights exercise cannot exceed 72 hours from submission of a complete application. Torres holds that delays beyond 72 hours function as temporary prohibitions on the right, and temporary prohibitions are constitutionally equivalent to permanent prohibitions during the period of delay. Virginia's 45-day processing period, void. Component 4. The sensitive place saturation limit. Sensitive place designations cannot collectively cover more than 25% of publicly accessible spaces within a jurisdiction. Individual sensitive place designations may be constitutionally sound, schools, courthouses, government buildings with security screening, but when designations collectively cover more than 25% of publicly accessible space, the effect is functionally equivalent to a public carry prohibition. Virginia's community safety zone coverage of 78% of public space, void. The 25% threshold gives states meaningful ability to protect genuinely sensitive locations while preventing saturation that converts designations into comprehensive carry prohibition. The combination test. If a state imposes multiple components, even each within individual thresholds, and the combination creates a cumulative burden that functions as a practical prohibition for working-class citizens who lack time, money, or access to navigate multiple requirements simultaneously, the combination constitutes procedural suffocation, and the entire regulatory scheme fails. Number 2. Why 9 justices agreed. The constitutional bad faith doctrine. The documentation of coordinated evasion. Torres is unusual because the majority opinion includes an extended factual section documenting what the court calls the coordinated procedural evasion pattern. Using legislative records, attorney general guidance documents, and communications between state officials produced in discovery, the majority demonstrates that the 19 states' post-Carson regulatory packages were not independent responses to specific public safety concerns. They were coordinated implementations of a single strategic framework developed and circulated among state attorneys general in the weeks following Carson. The majority identifies specific communications in which state officials explicitly discussed how to maintain the functional effect of permit systems without the specific mechanisms the court prohibited. This documented coordination is constitutionally significant. It demonstrates the regulatory systems were designed to circumvent constitutional rights rulings, not to address public safety. Why liberals joined. Justice Jackson's concurrence is most significant. 9 justices do not agree on the scope of the Second Amendment's protection. We agree profoundly and passionately on the obligation of government officials to comply with constitutional rulings in good faith. What we have documented in these consolidated cases is not good faith compliance. It is a documented strategy of evasion that uses the forms of legal compliance, no permit requirement per Carson, while deliberately recreating the function of the prohibited permit requirement through accumulation of individually defensible prerequisites. This court cannot permit that, regardless of where individual justices stand on the ultimate scope of Second Amendment protection. Justice Kagan adds, I have disagreed with some of the Second Amendment decisions this court has reached in recent years, but the rule of law requires that when a court speaks, government officials comply. These states did not comply. They evaded. The constitutional bad faith doctrine. Torres establishes that when government officials respond to constitutional rights rulings by implementing systems designed to accomplish the prohibited outcome through different mechanisms, their compliance is constitutionally void from the outset. The regulatory system does not need to be individually unconstitutional. If the documented purpose was to circumvent a constitutional ruling, the system fails on bad faith grounds before the court even reaches the substantive question of whether each individual component survives scrutiny. Number 3. The 19 states in 3 tiers. Tier 1. Complete overhaul required. California, New York, Illinois, New Jersey, Massachusetts. These 5 states implemented the most aggressive post-Carson packages. California, 24-hour training, $800 to $1,200 cost, $275 processing fees, 90-day processing, 85% plus sensitive place coverage. All components exceed TORAS thresholds. Entire system void. New York, 18-hour training, $400 fees, 6 to 8 month processing, 80% sensitive place coverage in New York City. All components exceed thresholds. Entire system void. Illinois, 16-hour training, $200 fees, 45-day processing, 70% sensitive place coverage in Chicago. All components exceed thresholds. New Jersey and Massachusetts, comparable comprehensive failures. Tier 2, partial structural failures. Maryland, Connecticut, Delaware, Hawaii, Rhode Island, Vermont, Oregon, Washington. These 8 states implemented packages exceeding TORAS thresholds in some but not all components. Maryland, 8-hour training, $100 fees, 14-day processing, 45% sensitive place coverage. Training, $75 max, and fees, $50 max, are within thresholds. Processing delay, 14 days versus 72-hour maximum, and sensitive place coverage, 45% versus 25% maximum, exceed thresholds. Only the exceeding components are void. Maryland must reduce processing to 72 hours and sensitive places to 25% maximum. Tier 3, adjustment required. Minnesota, Colorado, New Mexico, Michigan, Nevada, Virginia. These 6 states implemented packages closest to TORAS thresholds. Component adjustments can bring them into compliance without complete system overhaul. Virginia, the TORAS plaintiff's state, requires adjustment in all 4 components, but the system structure can survive with those adjustments. The 30-day compliance deadline. All 19 states must within 30 days identify every regulatory component exceeding a TORAS threshold, cease enforcement of all exceeding components, submit compliance reports to the Supreme Court monitoring system, and establish emergency processes allowing citizens to immediately exercise rights without the excessive requirements. The timeline is compressed compared to the 90-day Morrison framework because TORAS explicitly finds documented constitutional evasion. A finding the court held justifies accelerated compliance. Number 4. Civil liability. What the bad faith finding means for damages. Enhanced damages theory. TORAS's constitutional bad faith doctrine is the basis for an enhanced damages theory in Section 1983 civil rights litigation. When state officials implement regulatory systems documented as designed to circumvent constitutional rulings, the intentional nature of the constitutional deprivation supports punitive damages, awards significantly larger than ordinary compensatory damages cases. The documented communications showing state officials explicitly discussing how to recreate permit system function without prohibited mechanisms establishes the intentionality element that punitive damages require. 3 tracks of damages exposure. First, ordinary compensatory damages for citizens subjected to excessive training requirements, fees above the TORAS maximum, delays beyond 72 hours, or prevented carry by excessive sensitive place designations, measured by the cost of excess requirements and the value of rights denied during excessive delays. Second, punitive damages based on the constitutional bad faith finding, available where plaintiffs demonstrate that specific requirements were part of the documented evasion strategy. Third, attorneys' fees under Section 1988 and all successful Section 1983 cases, meaning plaintiffs' legal costs are paid by the states, making cases economically viable for civil rights attorneys to pursue at scale. Class action scale. In California alone, where the post-Carson regulatory system was in effect for approximately 6 weeks before TORAS, the class of affected individuals is estimated at over 200,000. The aggregate class damages across 19 states, combining fee refunds, training cost reimbursements, and delay period damages, is expected to reach the hundreds of millions of dollars. Individual official liability for those whose communications documented the evasion strategy creates additional personal exposure for specific governors, attorneys general, and legislative leaders. Number 5. Your immediate rights and action plan. What you can do starting June 22nd. In all 19 states, acquire a firearm at any licensed FFL completing only the federal NICS background check, Federal Form 4473, and compliance with federal age requirements, no state training certificate exceeding 2 hours/S75 cost, no state processing delay beyond 72 hours, No state fee exceeding $50. Carry in any publicly accessible space that is not a genuine sensitive place, and that is not within the 25% of space that remaining lawfully designated sensitive places may cover. Any regulatory requirement exceeding TORAS thresholds is void, and you cannot be legally required to comply. Filing compliance petitions. If any state official or licensed dealer attempts to enforce any regulatory requirement TORAS has voided, file a compliance petition in your federal district court citing TORAS versus Illinois, June 22, 2026, identifying the specific requirement, identifying the specific TORAS threshold being violated, and requesting immediate injunctive relief. Gun rights organizations are publishing state-specific petition templates for all 19 states. The TORAS decision creates expedited 30-day compliance petition review, demanding fee refunds. If you paid fees to any post-Carson regulatory system above the $50 TORAS threshold, you are entitled to a refund of the excess. Send a written demand to the collecting state agency. Cite TORAS versus Illinois. Identify the amount paid. Calculate the excess above $50, and demand refund within 30 days. If not refunded within 30 days, file a Section 1983 claim for return of the excess. Registering for class actions. Contact the Firearms Policy Coalition, fpclaw.org, Second Amendment Foundation, saf.org, and Gun Owners of America, gunowners.org, to register your experience with post-Carson regulatory systems. Provide the state, the specific system encountered, training hours required, fees paid, processing time experienced, and any specific sensitive place designations that prevented carry. This registration feeds into the class action lawsuits being organized in all 19 states. Document your restored carry. Starting June 22nd, document your lawful carry in locations that the 19 states' sensitive place saturation previously prevented. If challenged at a location formerly designated as sensitive but now void under the 25% threshold, remain calm, cite TORAS versus Illinois, June 22nd, 2026. State that the location's designation exceeds the 25% threshold and is void, and contact a civil rights attorney if the challenge escalates. Number 6. What happens next? State responses and the broader implications. Expected state responses. The 19 states will respond along predictable lines. Emergency compliance adjustments, reducing training requirements to 2-hour maximums, reducing fees to $50, accelerating processing to 72-hour commitments, and reducing sensitive place designations to the 25% threshold. These adjustments may happen within days in some states, weeks in others, depending on whether they require legislative action or administrative adjustment. Legal challenges to TORAS itself. Some states will file petitions for rehearing, arguing that the procedural suffocation test is judicially invented without constitutional foundation. These challenges face the obstacle of 9-justice unanimity. New regulatory approaches. Legislative staff in all 19 states are already working to identify what can be done within TORAS's thresholds. 2-hour training, $50 fees, 72-hour processing, 25% sensitive places, and whether a system operating within those thresholds can serve any meaningful regulatory goal. The TORAS warning to all state legislatures. TORAS's constitutional bad faith doctrine warns every state legislature tempted to implement new gun regulations. If the legislative record documents that a regulatory system was designed to circumvent a constitutional ruling rather than address genuine public safety, that system fails constitutional scrutiny from its inception. State officials who put in writing that they are designing regulations to maintain the functional effect of systems the Supreme Court has prohibited are creating the evidence of constitutional bad faith that TORAS uses to strike down the regulations. Document carefully. Say quietly. Because the discovery process in TORAS produced the evidence of bad faith from documents that state officials apparently believed would never be seen in court. The full 2026 sequence. TORAS completes the 2026 gun rights revolution. Carson eliminated permit systems. Coleman declared replacement schemes void. Morrison established the 3-part constitutional framework. Cruz protected gun owners from Second and Fourth Amendment violations during police encounters. Hargrove extended constitutional protection to vehicle carry. TORAS applied the Morrison framework to procedural suffocation, the last major regulatory strategy available after Carson and Coleman eliminated prior approval systems. The progression represents a comprehensive dismantling of every major mechanism states have used to restrict the practical exercise of Second Amendment rights. What survives? Instant NICS background checks, age requirements, prohibited persons restrictions, genuine sensitive places within 25% coverage, storage requirements enforceable after the fact. Every other restriction mechanism has now been addressed by the 2026 Supreme Court sequence. Non-19 states. Torres applies nationwide, not just to the 19 consolidated states. Any state in any of the 50 states implementing training requirements exceeding 2 hours, fees exceeding $50, processing delays exceeding 72 hours, or sensitive place saturation exceeding 25% is subject to Torres challenge. Gun owners in any state encountering these requirements can cite Torres in federal court challenges. Constitutional carry states must watch for municipal-level Torres evasion. City ordinances attempting to impose what Torres has made unconstitutional at the state level. Bottom line, Torres versus Illinois, June 22, 2026, 9-0, all 9 justices. The procedural suffocation strategy is unconstitutional everywhere it has been applied. The procedural suffocation test, a combination of regulatory requirements that collectively functions as a practical prohibition on Second Amendment rights exercise, violates the Second Amendment. The 4 thresholds: training cannot exceed 2 hours /$75. Fees cannot exceed $50. Processing cannot exceed 72 hours. Sensitive place coverage cannot exceed 25% of publicly accessible space. Constitutional bad faith doctrine. When government officials implement regulatory systems documented as designed to recreate the function of constitutionally prohibited systems, those systems fail constitutional scrutiny from inception. The 19 states. Tier 1, CA, NY, IL, NJ, MA. Complete overhaul required. Tier 2, MD, CT, DE, HI, RI, VT, OR, WA. Partial component adjustment. Tier 3, MN, CO, NM, MI, NV, VA. Component adjustments within existing framework. Civil liability. Enhanced punitive damages from bad faith finding. Section 1988 attorney's fees available. Class actions organized in all 19 states. Individual official liability for documented evasion strategists. Your action plan. Exercise rights immediately within Torres thresholds. File compliance petitions for exceeding requirements. Demand refunds of fees above $50. Register with FPC, SAF, GOA for class action participation. Document restored. Carry. The 2026 sequence is complete. Carson, Coleman, Morrison, Cruz, Hargrove, Torres. Every practical restriction mechanism has been addressed. What remains is the enforcement, the litigation, the class actions, and the state's attempts to operate within what Torres has left them, which is significantly less than they hoped. Subscribe, because Torres versus Illinois is generating compliance adjustments, legal challenges, class action filings, and new regulatory development simultaneously in 19 states, and every development directly affects the constitutional rights that 9 justices confirmed cannot be procedurally suffocated anywhere in America. 19 states, 9 justices, 0 dissents. The suffocation strategy is over.